Glad to have you back. Now, Nigeria's Deputy Senate President Ekweremadu is once again in the eye of the storm.
The federal government has filed an ex parte application at the Federal High Court, Abuja, seeking an interim order for Ekweremadu to temporarily forfeit some of his allegedly undeclared properties worth billions of naira.
Ekweremadu is alleged to own undisclosed properties in the United Arab Emirates, the United Kingdom and the United States of America. In the UAE, he allegedly owns 8 property. In the UK, Ekweremadu allegedly owns 2 property, while in the US, he is alleged to own a 3-story portfolio.
Now back home, he is accused of not declaring about 9 properties located in highbrow areas in Abuja. Meanwhile, Ekweremadu says he has no assets to be forfeited to the federal government, as he has declared all his assets with a code of conduct burial as required by law. And with us in the studio now to look at this is a lawyer, legal practitioner, Evans Ufeli. Thank you for joining us. Good morning to you.
Thank you. Good morning.
And also joining us on phone is also a lawyer, Olatubosun Oshifora. Good morning to you, Bosun.
Good morning.
Good morning. Thank you for joining us on the show. Okay, let me quickly ask you, how do we even discuss this, really? Because the affected person says that he has no property to lose to the government because he declared all his assets in the first place.
All right. Basically, the way it works is this. You can look at it from a political angle, and also you can look at it from the point of law. If we want, let's leave the politics and look at law. If we look at it from the point, basically it says that a public official, once you don't declare your assets and it's found out, then those assets will be forfeited. The laws are clear. If you look at the Recovery of Property, the Recovery of Public Property Act, Section 8, states clearly that once a prima facie case is established against you, then those properties will be forfeited. The same thing also, if you look at the Constitution, Section 44(2)K, says the same thing, that no property will be forcefully taken away from anybody, but except in the quest of maybe inquiry by court and all that, then such can be taken away from you temporarily until the case is established that, okay, fine, you got this through illegal means. So that's what the law says. So Ekweremadu can come out and say he won't forfeit anything to the government. But if he's found guilty, he's a lawyer and he knows the law. So if he's found guilty, definitely he will have to follow the law, and that's the position. So if the properties are found not to be declared and they belong to him, whether by proxy or otherwise, then such properties will be taken away from him, and that's the end of it. And he may even face trial in regard of the same charge. That's it.
All right, boss, so you hold on. We're going to be back with you, but let's now bring in Evans Ufeli here in the studios with us. Well, Evans, when you hear that the Attorney General of the Federation has taken the Senate, Deputy Senate President Ekweremadu to the CCT, are you confident that this would amount to anything, considering that Saraki, escaped the same thing?
Well, Saraki has not escaped. Just to backtrack.
But was acquitted by the CCT?
Initially, yes. But you know there is a resurgence.
Yes.
The case is up and coming again.
Yes.
Okay. So what I think here is that the level of investigation will determine the fate of this case. Because if you look at Section 330 of the Administration of Criminal Justice Act, it stated clearly that, when you do not have declaration, or you have forceful declaration, or you have incomplete declaration, because that is what they allege, from the declaration form they apply and got, which he feel, the last one, most of these properties are not there. That is to say that he withheld information. And if you look at Section 8 of the, Public Forfeiture Act, Public Property Forfeiture Act, you see that it's also there. The law is clear, Section the Constitution also, in Section 44(2)K also have already captured all this. But the main issue here is this. The problem we've had in prosecution in Nigeria, high-profile prosecution, is that the politicians or the elite seems to weigh a lot of influence that sometimes even beclouds the judicial system. And because they have the wherewithal, they have the means, you know, to try it and to subvert the cost of justice. Then it's difficult. But if the federal government have put their house in order and they have a prima facie case established, what they applied for was an interim forfeiture. It's not here because you have to come with evidence to court, and the adverse party, which is Ekweremadu, will have to file his defense. Okay, then upon the preponderance of evidence, okay, or proof beyond reasonable doubt, both put together, whichever way you look at it, then a case is established. Then you can now have a ruling, okay? And when you have a ruling to that effect, then you can now talk about the forfeiture. But there are still openings, whichever way the case go. The adverse party can still move on to a higher court. This is the Federal High Court. Happens to be the court of first instance in this case. So there are still windows upon which you can. And another question you ask yourself is this: how expeditious is the judicial system? Look at Saraki's case. From what year to what year are we? His tenure is almost gone, okay? The first tenure is almost gone. And the case is still dragging. So this one we're instituting now, how quick and expeditious can we get, you know, dispense of it? And now, you know, get justice. Because even the delay itself also stifles the present structures of justice. So, and when you look at our judicial system vis-a-vis the elite, okay, you find out that there is a collusion somewhere where justice is slowed down so that it can be easily subverted, so that it can also easily get away from the mindset. Because when you overdrag, most of the witnesses who are going to come and testify for or against, sometimes they are transferred, sometimes they are no longer there, sometimes they are dead, sometimes you have a lot of issues. So in as much as we want to fix Nigeria, we should not try to fix it in isolation. We should not try to fix it by employing Keamu or one other lawyer to go and clamp down on this and go to court. That's not how to fix Nigeria. The way to fix Nigeria is to activate the institutions, you know, give them their required constitutional power. Okay, and allow them to function without fear or favor. That is the only way you can now push forward for this correction.
Now, who does that? It's still the same people in the system that would have to put that system in place. And if they see that you don't favor them, will they go ahead? We'll come to you on that. Latubosu, bringing you in now. Now, the ground says that Ekweremadu didn't declare the properties in Schedule B were not declared in the Schedule A, and they found out, the federal government said they found out that he already owned those properties in Schedule B while declaring those in Schedule A. So what are the loopholes really? Because Ekweremadu is saying that he declared all his properties, but then let's look at it. What are the implications of this if they are able to establish, because we know that the burden of evidence is basically on the prosecuting team?
All right. Basically, you're almost speaking like a lawyer. All right. It's clear. Once a case is established against him, like my learned brother there said, they will have to, go to the court. Then the court will now look at it. They will weigh it based on the preponderance of evidence, and then that's when a verdict can be given. All right. So what happens now is a temporary forfeiture. All right, based on the application that's being brought by Kenyamo on behalf of the federal government to the court. Right, so basically what will happen is that if he's found guilty, or if it's found that he didn't properly declare those things, and he's had them and he's supposed to, definitely if you put that on a scale, then he will be found wanted. And then the court will order forfeiture of those properties. All right, even if he appeals. Now, but one thing I want to point out is this. This is a criminal allegation. It's a criminal case, as it were. And criminal case exists in perpetuity. It's not something that's going to go even if his tenure is over. So the case will continue. So about expedition and everything, but basically what I think is that this case will continue much after he's left office, and it will go on until justice is served in this. So the implication is that if he's found guilty, he's liable to forfeit all these properties. Basically, that's it.
All right. Evans, is there a way that we can say that prosecution is always in a hurry to go to the court when cases haven't been fully established? Because we have seen instances where high-profile cases have been lost you know, because of no case, no evidence, you know, and all of that. Is there a sense in which you can say there's always a rush in trying to, you know, prosecute people?
Yes. Sometimes most times, you know, we always have a rush. EFCC rush a lot, most of the times, okay? But it is not because they rush, that is why they lose the cases. It is because they don't devolve forensic investigation, a forensic way of, we're still doing a manual process of investigation. And then the world has moved from industrial age into the information age. Now people commit crime with gadgets and modern technology. And then you are using crude process to prosecute and investigate them. So you see the lopsidedness of so in this case, what we need to do is to begin to go back and look at what is the most recent procedure for which investigation can be procured, okay? And we need to devolve that, we need to create that, okay? Because if you look at it, the law is that once there is a charge against a person, okay, you must prove your case beyond reasonable doubt. Okay? And proving your case beyond reasonable doubt entails a lot. The reason being that once there is a loophole, once a doubt is created in the mind of the court, the law is that it must be resolved in favor of the accused person. That is why most times what a smart defense counsel will do is to make sure that he discredits the prosecution, create doubt in the mind of court, puncture all the evidence before the court, and then allow the court to now form its own opinion whether or not, you know, prima facie case have been established and whether the prosecution has proved beyond reasonable doubt. Because the law is this: you must prove your case. The prosecution must rely on the strength of its own case in proving his case, rather as against relying on the weakness of the defendant's case. So whether the defendants commit the offense or not, whether the court is aware and have seen that yes, he committed the offense, the prosecution, that does not in any way immune the prosecution from proving beyond reasonable doubt. Because no, it's a journey to justice, okay? And justice must be seen as manifestly done in cases like this. So that is why the court is careful. The court wants a situation where the prosecution must have proved his case and the evidence against the defendant is overwhelming. And no courts, higher or lower, will be able to doubt or dismiss, you understand, that part before the court will reach its own. But in doing that, like I said, it takes a whole lot of time. Like my learned friend said, criminal cases exist in perpetuity until justice is delivered. But the only problem is when it overdrags, then sometimes it begins to interfere with causes and effects, begin to trample on the processes and maybe witnesses and people, and compromise, you know, can be easily made as a result of the long passage of time. So
witnesses could be tainted. All right, because of time, Olatubosun, on a last note, I'm sure you heard what your colleague just said, and that is why, of course, we hear that the court is not Father Christmas. And we've seen so many cases in the country bungled by prosecutory teams, really, based on technicalities of the judicial system.
Yeah, most times the problem is that most of these cases are politically motivated. I mean, we're not taking our eyes off 2019. So we know that there's something brewing. That's why this is coming up. Ekweremadu has been there. Fine. It's whenever you find that, certain things against someone that you come to court with it. But they cannot tell us that they've not known this all this while. So most times when you see things like this, you find out that cases are bungled because they are politically motivated. So once there is some amicable settlement or somebody crosses over to the other side, before you know it, the charges are dropped or the case will just fizzle out. And that's why you find out that it looks like most cases are bungled. But let's see how this will end. Like my brother said, Sarachi's case is there and it's looking like there's nothing coming out of it. So these two may go the same way, and it's just going to be one of those cases we've seen. But I feel that the government should actually stand up and actually come up with something concrete on this so that a precedent can be created, then people can take them seriously. That's my position.
All right, Evans. Well, he just said now that we're not very sure if anything in a concrete would come out of the cases. The maxim of law used to be de minimis non curat lex. Of small things, the law knows no cure, or the law does not deal with, minimal things. These cases don't fall within that maxim of law, do they?
Well, it depends on how you interpret it, okay? As far as I'm concerned, there is no small thing here, okay? Because the maxim itself sometimes is interpreted the other way around. It's actually that no matter how small an act or an omission is, the law will deploy all its parameters to, cure the effect, like we say that what do you call it? Sorry, ubi just ibiremedium. Wherever there is a wrong, there must be a remedy.
Yes.
Okay, so that is the extent to which the law prevails, and why the law is set to check public officers is because they took an oath, okay, upon assumption of office, to declare their asset, to be diligent, and to, help the Nigerian state to assess democracy. That is the essence. So they must live above board. That is why they are called honorables, okay? So where you now have infractions, okay, where you now have, this kind of contravention of laid down clearly stated laws, okay? The next is to whether it is political or not, okay? So long as there's a prima facie case, the court will hear both parties, okay? But the court must give fair hearing to both parties to arrive at whatever decision he decides to give.
All right, Evan Sufeli, a lawyer and also a public affairs commentator, we must thank you very much indeed for coming to share your thoughts.